let's bring you some analysis now on the Zuma judgment from this morning from the High Court. Where does this judgment leave the former president? Will he go all the way to the Constitutional Court? What are the requirements for a case such as this to be heard in the highest court in the land? Well, Tyrone Maseko is a legal analyst at T Maseko Attorneys and joins us now for that analysis and that conversation. Firstly, Tyrone, the hope now is that, at least as far as Judge Piet Koen and the prosecution are concerned, that the trial will proceed on the 11th of April. How significant was today's decision in that trajectory to getting us to the starting gates of State versus Zuma, finally?
Good afternoon to us and to your viewers. Well, I guess it's the obvious thing that has to happen now, given the fact that we've had this application which has now been dismissed. And I was quite interested in the decision by the learned judge in how he deals with this question of was it even allowable in the first place that they should bring this application? Because my view has always been that you cannot challenge an interim decision, let's refer to it as an interim decision, in a criminal trial like this, until the matter has finally dispensed with. So either we've come to the end of the trial, so either you've been convicted or not. So that for me was a pertinent question, which I'm glad was answered. But that having been dispensed with, now we really should proceed to the trial stage.
But has it been dispensed with, Tyrone? I know that in terms of the court processes, it has, in that there's a judgment that has been delivered. But in terms of settling the matter as a dispute of sorts that's playing itself out, whether in the background to this case or one way or another. I heard, for instance, Mzwanele Manyi of the Jacob Zuma Foundation saying that, now the goalposts are shifting. Interlocutory applications are something that happen all the time in the courts. And now when Jacob Zuma wants to do exactly the same, he's being told that he's wanting to appeal in a piecemeal manner. So it would seem that as far as the defense of Mr. Zuma and those associated with him, there's still a dispute here.
Tulas, with all due respect to Mr. Manyi, what we're dealing with here is law, and we lawyers operate on the basis of the law, whether it be common law, statutory law, whatever, but we have to operate within the law. What does the law provide in circumstances like this? There's nothing novel, absolutely nothing novel on the question of whether one can take an issue, a ruling, if you like, on appeal in a criminal trial before there's a finalization of the matter. I remember that I don't even need to look it up. I remember it from decades ago, law school, that you cannot do that. And there's a very good reason for that, not just to frustrate litigants. It is this principle of finality to legal proceedings. What you don't want is a situation where the main issue here is Jacob Zuma's guilt. That is what has to be determined, not the interim and interlocutory issues that keep coming up, as it were. Yes, they can be dealt with by the court, and there are provisions for that in our law, and they do get dealt with. We've seen in this matter more than once we've been dealing with all these interlocutory issues. But the point is that what we're really concerned with is whether he's guilty or not. So that's the primary decision. Judge Koen actually made this point very, very well and said, look, at the end of the day, all of these issues become moot if he is found not guilty. So it makes no sense then to spend copious amounts of time and money on interlocutory issues which become irrelevant if Jacob Zuma were to be acquitted. And that is really the principle in law behind the idea of ensuring that there's, and some of them, we can have a simple issue as a question of whether evidence is admissible or not. Imagine if you could stop a trial purely on the basis of, well, this judge has dismissed my argument that this particular evidence is admissible or not, and now the trial must come to a stop while this issue is being taken through the various hierarchies of our law, all the way to the Constitutional Court, and then another issue is going to arise, and it becomes repetitive. So it's to prevent that we say, well, let's conclude the issue of guilt, and then you can appeal whatever you want. So it's not limiting your right of appeal. You can always appeal, but you must wait for the conclusion of the trial.
Yeah. Just on the other question that, that seems now to be the main point of contention for Mr. Zuma's team, the prosecution being led by Billy Downer. We'll know that was the source of the original judgment that had been delivered, ruling that had been delivered in October last year. Was it ever in doubt in your mind that the law is settled on that matter? The question of whether perceived bias of a prosecutor automatically, without anything more being said, disqualifies that prosecutor from leading the prosecution and strips them of title to prosecute. Were you ever in doubt that Judge Pitkun was going to find that this matter has been dealt with by the Supreme Court of Appeal?
Yeah, no, I was never in doubt, and the reason is that if you read that subsection in the Criminal Procedure Act, it deals with title, and you have to give title its ordinary grammatical meaning. We're not dealing here with the motives of a prosecutor. That is irrelevant. I mean, for that, if you're not happy with the motives or the otherwise conduct of a prosecutor, you can always complain to, and the avenues for dealing with it, you can complain to the NDPP, all sorts of procedures, discipline, and the like. But there is nothing that in our law that requires that a prosecutor has to be objective, as it were. In fact, the prosecutor doesn't even have to afford you a fair trial. The court has a right to ensure that the trial is fair. So prosecutors are partisan, just like us defense lawyers are partisan. We defend our matters. Sure, yes, we're not allowed to lie. We're not going to get into it. It's another issue completely. But you don't have to be partisan. You have to be partisan, quite frankly, in adversarial processes. And so it does not matter what motivates Billy Downer. The question is, does he have standing? And standing really relates to, have you been duly appointed? Is there any reason why in law, procedurally, you cannot conduct this trial? Have you been appointed? You held the appropriate certificate from the NDPP appointing you as a prosecutor. If those boxes are ticked, that's the end of the matter as far as I'm concerned. Your conduct does not relate to, it is not a consideration as to whether you should be in a position to trial the matter or not. If someone's not happy about that, they can complain, the NDPP can remove you. But as far as the court is concerned, your standing is, you're in good standing for as long as, quite frankly, your papers stand up. Now, and that for me, really, that was the end of the issue as far as I was concerned.